hearing of the matter between the federal government and the National Association of Resident Doctors, parties report to the court the outcome of their negotiations as agreed. The federal government told the court that negotiations have collapsed. It consequently filed a fresh application asking the court to compel the striking doctors to go back to work. Counsel to the federal government, Tochukwu Maduka, said unless the application is granted, there will be irreparable loss to the country by the time the court concludes hearing the case. Defendant's counsel, Robinson Ario, asked the court to consider the balance of convenience as the doctors are open to various degrees of injury. Defendant's counsel, Robinson Ario, asked the court to consider the balance of convenience as the doctors are open to various degrees of injury and maybe death if they are to return to work without the issues being resolved. Justice Bashir Al-Kali, in his ruling, asked the doctors to return to work, holding that the government has shown that damages that would arise from the continued strike will be irreparable.
We basically adjourned to sign that MOU, only for the defendants to come up with entirely different agreements, which introduced new issues in the MOU, which they had agreed to just go back from court and sign. So practically they walked out of that agreement, and as was reported in the press, I think yesterday, they walked out also on the meeting with the Honorable Minister. So when we came today, the matter for today was to report settlement, or the court will proceed to deliver its ruling and take the applications pending. So parties we added them on our own parts and on the part of counsel for the defendants. They considered that negotiations had broken down, and their lawyers specifically said they were prepared to match us on the processes before the court.
The minister did not even come out of his office to meet our client yesterday. The minister, according to our client, only sent his aides to our client, the president of our client, that they would be consulting their lawyers. So we expected that in the interest of the masses who have no means of going abroad for medical care, the government ought to have been interested in looking into the new timelines. No new issue at all. No new issue at all was introduced. We argued that under the law, preliminary objection takes precedence over any other application, and particularly it takes precedence over the interlocutory application for injunction by the claimants. The court overruled us and held that the court would take the interlocutory application for injunction first, and that our notice of preliminary objection would be taken along with the judgment on the substantive suit.